I'm Amy Whitworth. I'm the Director of the Office of Elder Justice, a division of the Administrative Office of Pennsylvania Courts. I want to start today by thanking Judge Murphy and Judge Wood-Skipper for their opening comments, and to just take a moment to acknowledge their leadership, both of the Advisory Council on Elder Justice and also as co-chairs of this fantastic summit. Can you help me do that? It has been a great honor and privilege of my career with the Administrative Office of Pennsylvania Courts to work alongside you on these elder justice issues. And in this moment, I am very full of hope, and I'm excited to continue this work. Our summit theme is transformation, and I invite you now to our first session, Transformations in Pennsylvania, Part 1, Perspectives on Guardianship. So this afternoon, we have collected for you a series of testimonials, each representing a different perspective on guardianship in Pennsylvania. So we begin with Stephanie Bates from Newport, Pennsylvania, which is in Perry County. She's the mother of a 19-year-old son with severe physical and cognitive disabilities. Her son, Trent, is currently served through less restrictive alternatives to guardianship, but Stephanie shares the challenges that she's encountered in navigating his care.
Trent was my first child and had a normal pregnancy. Everything was fine. Normal birth, everything was fine. I thought it was great. Everything was great. But it was quickly realized that it was not fine. Right away, Trent was having feeding issues and so forth like that. But they did say that he passed his tests, and they did send him home 2 days later. And so I had this brand new baby and was just really trying to maintain food in his belly and just settling into this motherhood. And but slowly realizing there were things that weren't quite right, some red flags, and Trent was actually born in October, and it was by Christmas time that we realized, me and my sisters actually realized that Trent wasn't really focusing. He wasn't making eye contact. He wasn't holding his head up. My sisters, who had more experience with babies and children, said, I think by this age he should be doing this, or something's not quite right. So really started to take him to see doctors about everything. As far as my journey as a parent, what really shaped my experience was that pivotal diagnosis eventually that we received after the feeding issue, and then it came to our attention that he had some vision problems, he had some developmental delay, wasn't really meeting milestones with things like holding his head up and such. Hearing the doctor say, your son has an intellectual disability, he has a neurological disorder, he's deaf and blind and will never walk, never talk. It just hit me. All these diagnoses came flying at me. And realizing that we had a really long road ahead. And so just began, really navigating the healthcare system, taking my son everywhere, seeing every specialist, just trying to fix him or, get a cure. This isn't happening to me. And there's just a lot of emotions that come with having a special needs baby. Really is the fear of it. I felt guilty in some way. A lot of guilt came over me, and a lot of sadness and anger, and just very, very stressful times, months and really years of just total stress that is unbelievable. I did along the way get some supports. I found a lot of support through early intervention. I had these wonderful women would come to my house every week, would help me with, feeding and nutrition. Eventually we got vision services, physical therapy. And I just relied on these women, and they really carried me through those times. And then after age 3, he had to go to school, and I had a really positive experience, through all of Trent's schooling. Even today at 19 years old, the schools have always been wonderful. The children that attend school with him are amazing. That was a big fear of mine. I thought that the children might be cruel, or he might have a bad experience, but no, it was the opposite. The kids were great to him. Eventually, through all these years, all of those emotions that I felt have really just turned into acceptance of this, and there is a peace in that. Just loving Trent for who he is unconditionally, just really getting a lot of joy out of him, and just really strengthened my character and who I am as a person. It's been hard. Of course, there's been ups and downs, but in the long run, with a lot of support and help from not only these agencies like Early Intervention, also the Patent Group, to support me in this, and family and friends. I mean, I feel blessed in my life. I wouldn't change anything now when I look back on it. As he is getting older, I am finding that I am getting some stumbling blocks with not having guardianship over him. And at times, healthcare personnel will ask me, can you put Trent on the phone so I can get verbal permission to talk to you? Well, no, he doesn't talk. Or, they want some agency or some entity might want his signature on something, and he can't do that. So, so far, I haven't got a lot of pushback on the things that I've been taking care of for Trent, as far as medical things and financial things like that. But I feel like it's something on the horizon that's coming at me. I intended to pursue guardianship for my son, but I don't know what I'm doing. I didn't know where to go or what to do. So I just contacted my own attorney, who basically hit me with the price tag, and I wasn't able to move forward with that, to be honest with you. I was told a $3,000 retainer, and it wasn't stopping there. And so I had to cut it off, and I just thought, I'm going to put that on the back burner until later and deal with it later, because I have a lot to deal with on a daily basis. And so I moved on from that. So for me, initially, it was the money. It's the cost of it. That's a lot of money for me as a single mother. That's a lot of money. It's been a long road, believe me, but I swear I wouldn't change any of it. I love Trent. I love what he teaches me about myself.
And this is why we do what we do. So next, I would like to welcome to the stage Dr. Tawanda Sanders-Williams. She's a nationally certified guardian, to discuss co-guardianship and collaboration with families and best practices. Dr. Tawanda Sanders-Williams is the sole proprietor of Cultivation, Enrichment, and Growth, LLC, a business whose purpose is to support relationships and communities in healing and restoration by achieving sustainable change.
Good afternoon, everyone. I dare you, reimagining guardianship through transformation. When I read the title of today's event, Transformation and Guardianship, a childhood memory came rushing back. After homework, I was allowed to go outside until the street lights came on. And just before it was time to go inside, someone would always yell, "Tawanda, I dare you." Now, if you've ever played I Dare You, you know it wasn't just a game. It was a challenge, a test of character. And for me, it usually involves something related to food, some food that I hated. I dare you, Tawanda, to take a bite of this raw onion. I double dare you. I triple dare you. And as much as I hated it, I'd take the bite, because the dare pushed me past what I thought I could do. And that's what transformation is. It's the adult version of I dare you, a bold invitation to rethink how we care, how we support, and how we advocate for others. And let's go back. In the 1980s, kinship foster care emerged because Black families demanded to be trusted to be caregivers. That was transformation. In the 2000s, Dr. Arthur Evans reshaped Philadelphia's behavioral health system by placing people at the center of care. That was innovation. So what does transformation look like in guardianship today? At Cultivation, Enrichment, and Growth, LLC, we live the dare every day, and here's how. I propose to hospitals single-case financial agreements to create custom discharge plans for those individuals stuck in hospital for non-medical reasons, like 2 women that I'm currently serving as guardian for. One has been residing on a hospital ICU unit for 2 years because no facility would take her because of complex mental health treatment needs. The second, a young lady, had to have 2 partial amputations of her lower extremities. And after I gave consent, it was discovered that she was in a 2nd trimester pregnancy. And we didn't wait for the system to fix itself. We had to create a pathway out for them both of the hospitals. A woman's sister once refused to serve as guardian because she said she was afraid of the reporting requirements. But through co-guardianship with me, she now visits her sister daily, advocates strongly for her sister, who will soon transition to a less restrictive setting. Our motto at CEG is collaborative, community-rooted, and relationship-based, including those who love them. Currently, we work alongside 27 biological family members across 3 states. 11 now are court-appointed co-guardians along with me. We currently work with a neighbor, 1 Greek Orthodox priest, and 1 church member, all partnering to keep loved ones thriving in their communities and their own homes. We meet with orphan court judges outside of courts to find human-centered paths for complex cases. Our goal is to always collaborate and not just litigate. So what does transformative guardianship mean? It rejects isolation in favor of collaboration. It centers on relationships, cultural relevance, and dignity. It makes co-guardianship a standard of practice and not just a rare exception. It reimagines the guardian's role, not just a manager of care, but as a connector, an advocate, and a partner in possibility. Today, I'm daring you. Transform how you approach guardianship. Take a break from tradition. Lead with boldness, heart, and humanity. I double dare you. I triple dare you. I quadruple dare you. I dare you, I dare you, I dare you. Reimagine guardianship. Reclaim dignity. Restore possibilities. And say yes to the human experience. And as you leave the summit, ask yourself, what would guardianship look like if I said yes to the dare? Thank you. Let's keep talking, and I'm listening.
Thank you, Dr. Tawanda Sanders-Williams. Next to the stage, I'd like to welcome Mary Catherine Scott Esquire from Widener Commonwealth Law to discuss Widener's innovative court visitor volunteer program for law students and pro bono attorneys. Mary Catherine is an associate clinical professor and director of the Central Pennsylvania Law Clinic at Widener Law Commonwealth. In that role, she supervises 2nd and 3rd year law students representing indigent and elderly residents of Dauphin County. Professor Scott is the recipient of the 2021 Central Penn Business Journal Legal Excellence, among many other awards, and she's also a member of our Advisory Council on Elder Justice. So welcome, Mary Catherine.
Thank you, Amy. I'm so very happy today to talk to you about a very revolutionary and transformative program that we have here in Dauphin County. It's called the Dauphin County Pro Bono Monitor Program. This program was started in 2007 by the late Orphans Court Judge Todd Hoover, and he recognized the importance and the duty that we all have in safeguarding the most important population, a very vulnerable population, and that would be the alleged incapacitated people. And through this program, he organized an effort where volunteer attorneys could get their pro bono credit and go out into the community and monitor guardians and guardianships and meet with the ward and review financial documents in order to act as the eyes and ears of the court. The volunteer attorneys go into the guardianship proceedings, post adjudication, and write a report to the court, noticing any irregularities, any issues, any potential for abuse, neglect, exploitation. And through that report, the court is able to have a review hearing if necessary to see what exactly is going on. We all recognize the GTS system and how important that has been in the last several years helping with this effort. But having eyes on the guardianship and the guardianships that are assigned to these volunteer attorneys has been instrumental in making change and providing these safeguards for this population. Tomorrow in a session, I'm going to talk about the nuts and bolts of the program, but today I'd like to just give you a war story where this really happened in real time. Last summer, we met with a guardian and a ward for the very first time. It was our first assignment, and the guardianship had been established several years ago where our 60-year-old ward had suffered a brain injury, had had a stroke, and was currently in a rehab facility. And as soon as we got there, we realized that this might not be the textbook case for a guardianship. She first clearly let us know she was fine, she didn't need a guardianship, what can we do to help her? And of course, we let her know that we weren't representing her, we were just, an officer of the court, here to help the court decide what was going on, in her guardianship since she was named a ward after the petition was filed. And so the student and I, wrote a report. It was read by the court, and the court did in fact hold a review hearing. At that point, she had had her two brothers as the named guardians for her, and they were able to come into court. The judge, in fact, it was Judge McNally in this case, was able to meet with our ward. And it was determined that, in fact, a guardianship wasn't needed. We could find some least restrictive alternatives to help this woman and to help her family, support her through this process. In fact, the judge named her one brother as the power of attorney. And, she still had some issues that needed to be addressed. And we were able to come together collaboratively to find a situation where somebody could come in, help her with her meds, help her with her groceries, and live a little bit more of an autonomous life. And so this is just one example of where this program, this monitor program, is able to help the court and post-adjudication find out what's going on in the guardianships and make sure there's no issues with these situations. And it's really a program that I'm looking forward to talking to you more about tomorrow, but letting you know that this is something that we hope that you can bring back to your counties and talk a little bit about some of these neat ideas that we've been doing here in Dauphin County. So thank you for your time.
Many thanks, Mary Catherine, for being here with us today. I now wish to welcome Michelle Cluck, Esquire, from Mid-Penn Legal Services Organization to discuss successfully arguing for alternatives to guardianship as a legal services attorney in a collaborative LSO pilot project between the Advisory Council OEJC, and Mid-Penn Legal Services. Michelle is a staff attorney with Mid-Penn Legal Services, where she practices in the area of guardianship defense for Dauphin and Cumberland counties. So welcome, Michelle.
Thank you. As a guardianship defense attorney, my job is to zealously advocate for my clients' wishes, not to act as guardian ad litem, making decisions is what I feel is in their best interest. And believe it or not, sometimes that actually means advocating for our guardianship. Take Betty, for example. I met with her several times. We reviewed the petition, and I explained to her what guardianship was, and she basically had a good understanding. She told me, I want a color, I'm tired, and I want someone else to make the decisions for me. And I understood, because I usually feel that way at 4 p.m. on Fridays. I explored limited guardianship with her, discussing any specific decisions she wanted 100% control over. But she clearly stated she wanted a guardian and could articulate why. And that's exactly what she told the court. In Betty's case, to Judge McNally's surprise, I advocated for guardianship. However, I stayed in the case and visit the client often just to make sure guardianship meets her expectations. Other times I fight hard to avoid guardianship. Bob was in rehab following a surgery. He claimed he was injured during physical therapy and refused to pay for his stay or apply for Medicaid. He owed the facility quite a bit of money. The facility responded by filing for guardianship, essentially using guardianship as a collection tool. Their expert report stated my client was totally incapacitated. This was because he chose not to discuss his finances with an expert in an over-the-phone evaluation. The petitioner went as far as to say Bob could not come to court. It would be too difficult and cause him harm. After an independent evaluation and Bob's in-court, in-person testimony at the guardianship hearing, the judge found he had capacity and the guardianship was denied. In some cases, we find alternatives that protects the client and allows them to keep their autonomy. Doris lacked capacity since birth. After her parents died, her siblings cared for her. One facility refused to share her medical information with the family without a guardianship order. The family had to pay for an attorney, but did not want to be their guardian or have guardianship for Doris. They just wanted to keep doing what they have been doing for the past 50 years. Opposing counsel, the court and I worked together to draft an order enforcing the healthcare representative statute and Social Security representative payee designation, but denying guardianship. We tried less restrictive alternatives. We made sure that an expedited review hearing would be held if any of these less restrictive alternatives did not work, but it's been over a year and there have been no issues. And then there's Danny. Danny's children took him from a home near Texas, drained his bank accounts, and admitted him to a facility in Harrisburg, Pennsylvania. Following a hearing, he was adjudicated totally incapacitated, and a plenary guardian of his person and estate was appointed. But what mattered most to Danny was to see his family, and that's all he could talk about. Danny's brother learned of his whereabouts, contacted the facility, and talked to Danny. Danny's capacity began to improve. There was concerns that he would not be able to fly to his brother's home, but Mid-Penn Legal Services, with the support of Danny's social worker, filed a petition asking his brother be appointed as substitute guardian and allow the client to move closer to his brother. Danny was then adjudicated a partially incapacitated person, no longer totally incapacitated, and he moved to an independent facility near his brother, spent Thanksgiving with his large family. This move was over 1,000 miles away from Harrisburg. And finally, there are times where clients cannot direct litigation, but the petitioner still has to meet their burden. At one hearing on cross-examination, a physician admitted he never met with my client. He signed a report that was completed by a facility administrator. That doctor no longer testifies as an expert. And this is why advocacy matters. Whether it's fighting for a client's autonomy or supporting their desire for help, our role is to listen to the client and make sure they have a voice. Because at the end of the day, guardianship just isn't a legal process, it's a human one. Thank you.
Thank you very much, Michelle. Next to the stage, please help me welcome Bob Lodge, Esquire of Disability Rights PA, to discuss observable changes in practice since the implementation of Act 61. Prior to working with Disability Rights Pennsylvania, Bob worked as an assistant public defender, where he became chief of diversionary and reentry programs, which included mental health treatment court and other specialty courts. His focus during his career has been to represent people with mental health and other disabilities in the legal system. Welcome, Bob Lodge.
Thank you. Thank you. So I've been with Disability Rights over the last 4 years, and when I came there, I was under an ABLE account, an IOLTA ABLE account. I was reading something else there a minute ago. I was able to just represent clients, young adults with disabilities in guardianship cases. And so I was able to meet my clients, discuss with them their interests, their abilities, their goals, and get as much information as I can about them. And that process was a great process, and it was a needed process. And I thought to best represent them, this was needed. And I was then able to meet with opposing counsel, whoever's filing this petition, and we were able to discuss this information and then also discuss these less restrictive alternatives and discuss these other tools that can be used. So by going through this whole process before we even had to be in court, we got to discuss what were the problems, what were the goals, what was needed, and really flush out how we can help best, how the court can help, and we're able to do all of this before we're even in court. And the benefit of that is that I have a better understanding of my client, and it gives my client a voice. I get to speak for them in court, I get to speak for them out of court, and that involvement allows for better outcomes. It involves better understanding of what the court order can and can't do, and how these tools can be used, and whether it ever needs to be changed, whether we don't need a guardianship and someday we may. So this outcome that I've been able to see prior to Act 61, it was fundamental in this whole process. And now with Act 61, that is mandated that the client in this process has a voice. It creates better outcomes for all parties, and it creates someone that, one, if the client needs to be informed, has a question, it has someone they can then go to. It has the ability to enforce that order if needed, appeals, review hearings. So it empowers this person with a disability, and my focus is typically young adults, and it gives them this voice early in the process, and it doesn't take it away. And I think before this, without having that representation, whether it was intimidation, whether it was a difficult process, it's hard to have that voice in court. Sometimes it's hard for me to get a word in court, and I've been doing this for a long time. So to be able to speak for that person gives that better outcome and pushes for discussion with all parties on what change is needed, what order is needed, if anything is needed. And we have better outcomes in court by having that ability to argue and have that back and forth push and see what's needed for the client. And I think it's a huge step, and it's a huge step in the process. Our view of people with disabilities has changed over the last 50 years, and what someone can do, what someone can't do. I think with Act 61, our law has changed, and I think with doing what we're doing here and with the judges here and with the representation, we're evolving these orders, we're evolving to how someone with a disability is viewed, their voice isn't taken away, and they have that ability to continue doing everything they can do. And by giving them this voice, it allows them not just to be taking something away from them, it allows them to say, this is where I also need support. So it's an interactive conversation now, where before it was saying, well, prove to me you don't need a guardianship. And now it's saying, what can we do to support this person, and what best here, and gives everyone a better understanding of the whole process. So it's been a huge change, and I think as we continue to push in all the different counties throughout the state, that we're making sure this representation is happening, giving people with disability a voice. It's a great change, so thank you.
Thanks very much, Bob. It's now my pleasure to welcome to the stage an esteemed panel of judges and government officials who have compelling testimonials about guardianship to share. So I'm going to call them all up together, and they'll sit wherever they like in whatever chair they choose. You get to choose. And then I will call on you one at a time and provide a very abbreviated bio because all of your bios are very long. Okay, so I first want to welcome President Judge Sean Myers from Franklin and Fulton counties, and welcome back to the stage Judge Lois Murphy of Montgomery County. We're also honored to welcome Senator Maria Collette and Secretary of Aging Jason Kovulich to join us. They're moving the chairs. Is that allowed? I didn't authorize that. Okay, all right. They're judges. They can do what they want. Okay, welcome everyone to the stage. We'll begin with P.J. Myers. Since January 2010, the Honorable Sean D. Myers has served as a judge for the Court of Common Pleas in the 39th Judicial District, which is the general court for both Franklin and Fulton counties in Pennsylvania. In December 2019, he began serving as president judge, and he is also the president-elect of the Pennsylvania Conference for State Trial Judges and has served on numerous committees. He's a current member of the Advisory Council on Elder Justice in the Courts. Please welcome President Judge Sean Myers.
Thank you. Is it okay if we sit? Amy, is it okay for us to sit, or would you like us to go to the podium?
I'm not really in charge here, Judge. You may
Okay. Can you all hear me?
You may sit, you may stand, whatever
Great.
floats your boat.
So you'll see a picture projected up there. That's a picture of my mother. Now, you may think I'm instantly going to tell you about a guardianship story that maybe involves her as a subject of guardianship, but that's not the case. The case I'm going to relate is the fact that a petition for guardianship was brought for a woman in my court, and a physician testified with great credibility that the woman lacked capacity. She was totally incapacitated. One of the key diagnoses, though, was mania, and the doctor was adamant that she had no capacity. So I granted plenary guardianship of the person and estate. She had apparently significant assets that her family were not cooperating to try and do a Medicaid application. And I was told sort of this terrible story of her basic need for guardianship service and also a need for preservation of her well-being in a nursing facility of which I knew really doesn't provide very good care. But it's a resource, right? And so, strangely enough, a few months later, her court-appointed counsel brought a petition to revoke the guardianship. And so we scheduled the hearing, and a woman came forward with her court-appointed counsel, who was her longtime friend, who spent half of her year in Florida. But the longtime friend was not able to return to Pennsylvania to spend time with her friend because she was undergoing medical treatment in Florida and couldn't return. And in about a 3-month window, her friend, unfortunately, had fallen out of the principal care of her psychiatrist, and she had been on an emergency placement out of a hospital into this nursing facility, and all of her medications have been absolutely, completely removed. She was left and rendered incapacitated, and the treating physicians of the facility failed to confer with her longtime psychiatrist who had served her for 30 years. She served as the guardianship officer in the South Mountain Restoration Facility until her retirement. Talk about the irony. Thing is, none of that history was ever shared with me. right? And the doctor who declared her incapacitated did so with great clarity and certainty, and he could not be moved off that. The hearing is scheduled. The woman comes in. She walks in and she's asked to take the stand. She takes the stand and she tells me about how she was able to be restored, thanks to her good friend returning from Florida, to her treating physician. She had now had several months of medication. She felt great. She wanted to pick a new place to live. She acknowledged she needed some supportive living, but she certainly didn't need to be in a nursing facility. And then she turned to me quite poignantly, and she looked at me and she said, "Are you Aunt Helen's son?" I said, "Yes." "Are you talking about Helen Myers?" "Yes." "I knew I was coming to see you, Judge. So I went through my old photo albums, and I wanted to bring you this picture of your mother, who I always called Aunt Helen. She was one of the kindest people that I've ever met." And she goes, "I want you to have this picture." So that's what the human connection means to me. And that's why I'm grateful for the amount of review we're doing and challenges we're making to presumptions about the need for permanent guardianship. So I want to thank Robert for facilitating the photograph being shared with all of you. I had just lost my mother 2 years before this hearing. So you may think that of all the photo albums I have of my mother that, I have a lot from the family. That's true. But this is a picture that I keep in my chambers. It's got a lot of important reminders for me before every guardianship hearing. So thank you.
Thank you, Judge Myers. I'll now invite Judge Lois Murphy to discuss a compelling guardianship termination experience about a determined and devoted family. Lois Murphy has been a judge of the Court of Common Pleas in Montgomery County since 2010 and serves as administrative judge of the Orphans Court Division there. She is currently the co-chair of the Advisory Council on Elder Justice and the co-chair of this summit. She works tirelessly. If you think I'm joking, you go ahead and you try to get an appointment or get on Judge Murphy's schedule. I'll wait. Yeah. She works tirelessly on elder justice, so please welcome Judge Lois Murphy.
It's a horse race. Is this working? Oh. Hello? Wait, that's it, right?
Yep.
Okay. Thank you, Amy. It's a horse race, keeping up with our staff. Robert was a little concerned that my story about a family and terminating a guardianship might be similar to Judge Myers, but there are similarities, but there's a difference. In this case, in the Williams family, they came to court in 2016. Mrs. Williams needed a guardian. She had long-term mental health issues that made her unable to care for herself much of the time. And she cycled in and out of mental health commitment, other hospitalizations, and became unhoused. And in 2016, a guardianship petition was brought, and she ended up in a nursing home, which for a time was meeting her needs, at least meeting her basic needs for care, for medical care, for housing and food. However, her symptoms were so significant that she frequently became belligerent with staff, she became disruptive, she became violent at times, and she would frequently end up back in psychiatric hospitalization. Fast forward to 2024, and a lot of good and caring people, including a professional guardian, did their best for her. In 2024, she had another psychiatric hospitalization from the nursing home, after which the nursing home where she had been residing would not take her back. The professional guardian sought out placements and was rejected by at least 25 different nursing homes because of her behavioral issues. And at this point, her sons, she had 3 surviving sons, decided to take her home. They knew the challenges. They knew that she likely will continue to need psychiatric hospitalization from time to time. but they were at a stage of life where they could better meet her needs. And fortunately for us and for her, they were collaborating and committed to her well-being. So one of her sons took her into his home, and her other two sons and her grandchildren were involved with her care, involved with her socialization, involved with meeting her needs. And they came into court on a review hearing, and we agreed that they could act as her healthcare representatives as a less restrictive alternative. I appointed two of the sons as healthcare representatives under an order, but vacated the guardianship. They no longer needed guardianship of the estate. They only needed a representative payee for Social Security income. And they're meeting her needs with less restrictive alternatives and in a collaborative way. And I just wanted to share that two of the sons at the hearing articulated to me how important they feel it is to involve her in decisions, to keep her informed and allow her some agency and dignity. So that was a really heartwarming and challenging guardianship matter, but I wanted to share that experience with you where also we were able to meet her needs in a less restrictive way.
Okay, thank you, Judge Murphy. So I now want to ask Senator Maria Collette to discuss the legislative process with Act 61 and its impacts. Senator Collette represents the 12th Senatorial District. She's a lifelong advocate for working families, having served as Deputy Attorney General in Camden County, New Jersey, as well as a nurse. With the goal of serving her community on an even larger scale, Senator Collette successfully ran for office in 2018, where she's been committed to working for Pennsylvania families. She is a current member of the Advisory Council on Elder Justice. Senator Collette.
Thank you, Amy. Hello? Yep. Whoa. Sorry. Thank you, Amy. And good afternoon, everyone. As you heard, I'm Senator Maria Collette, and I am really proud to represent the 12th District in Montgomery County. As the Democratic Chair of the Senate Aging and Youth Committee, I am also honored to serve on the Advisory Council on Elder Justice in the Courts. I want to thank our Chair, Judge Lois Murphy, from my backyard in Montgomery County, and our Vice Chair, Judge Sheila Wood Skipper, and of course our patron on the Supreme Court, Chief Justice Todd, for organizing our work, the work of our council, and for gathering us all here today as we keep our focus on the best practices for improving guardianship care in Pennsylvania. As you heard, before joining the Senate, I walked two very different professional paths that led me here today. As a Deputy Attorney General handling abuse and neglect cases, I saw the legal complexities of protecting vulnerable individuals. And then, as a nurse in long-term care, I witnessed firsthand the human impact of our guardianship decisions. During my time as a long-term care nurse, I met Janet. That's my mother's name, though this story is not about my mother. Janet fundamentally changed my perspective on guardianship. She was a retired school teacher, 78 years old. She came to our facility for rehab after a fall resulted in a hip fracture. She was sharp, she was joyful when discussing current events and reminiscing about her teaching days, but she often struggled with grappling with medical decisions that she was facing, and she had difficulty ensuring that her bills were being paid on time. Janet's adult son and daughter both lived out of state, and they were deeply concerned for her well-being. They believed that full guardianship was their only option to ensure Janet's safety and proper care. As one of her caregivers, what struck me the most was watching her spirit dim as she realized that she would lose authority and autonomy over even basic daily decisions, where she would live upon discharge, if she would even be discharged from our facility, which activities she would join, what clothes she'd wear, whether she'd be able to access her bank account to add that $5 bill to her grandkids' birthday cards, as she had always done in the past. What her family didn't know, and what too many families still don't know, is that there were then and there are now other options available. Perhaps the limited guardianship focusing solely on medical and financial decisions, or even a supported decision-making agreement that would have preserved her autonomy while ensuring that she still had the assistance that she needed. That's exactly why Act 61's emphasis on exploring less restrictive alternatives is so crucial. Janet's story, multiplied across thousands of Pennsylvania families, shows us why we needed reform and why our continued work matters so deeply. When I stood before you in 2023, we were anticipating the passage of then Senate Bill 506, and today I'm proud to report that bill became Act 61, signed into law by Governor Shapiro in December of 2023. This wasn't just a legislative victory, it was a victory for every Janet in Pennsylvania. Since the law went into effect in June of last year, we've implemented crucial changes. New certification requirements for professional guardians, enhanced safeguards for our most vulnerable Pennsylvanians, clearer pathways to less restrictive alternatives. But perhaps most importantly, we've codified into law what many of you in this room have long advocated for. Guardianship shouldn't be our default option, but rather one tool in a broader toolkit of supports. I see many familiar faces here today, judges who carefully weigh these decisions, attorneys who advocate for their clients' rights, and guardians who dedicate themselves to this crucial work. Your experience and commitment have been invaluable in shaping and implementing these reforms. As we move forward, our focus must remain sharp. With aging adults soon representing 1 in every 3 Pennsylvanians, our work is even more critical and far from over. We must still ensure effective implementation of Act 61. We must continue to expand education about alternatives to guardianship. We must support professional guardians in meeting the new requirements placed upon them, and we must strengthen our monitoring systems. Now, if you've been following anything coming out of Harrisburg or Washington lately, you know that it's quite challenging to get folks to agree on much of anything these days. That's why the unanimous support for this legislation received 2 years ago proves that protecting our most vulnerable while preserving their individual liberties and dignities transcends politics. It's about human dignity, it's about justice, and it really is about doing what's right. I'm excited to continue hearing directly from the participants and panelists in this summit, including one of the strongest advocates for improving the quality of life for aging Pennsylvanians in our state government, my friend and Secretary Jason Kovulich. I am eager to learn, like you, about what we can be doing better so that Pennsylvania's Janets and their families have a brighter future, a brighter, more independent, and more dignified future. And I want to close by saying thank you. Thank you for your continued dedication to this crucial work. Thank you for taking time out of your incredibly busy schedules to convene here to discuss how we can build on the success of Act 61 to make the future amazing for aging adults. And thank you for wanting to ensure a more just and effective guardianship system for all Pennsylvanians. Thank you.
Thank you, Senator. So we'll now turn our attention to Pennsylvania's Secretary of Aging, Jason Kovulich, who will discuss the Aging Our Way initiative and more. Secretary Kovulich brings 25 years of experience within the human services field to the mission of serving and advocating for Pennsylvania's older adults. In May 2023, he was unanimously confirmed by the Senate of Pennsylvania to serve as Secretary of Aging. Most recently, Secretary Kovulich has been appointed to not 1, but 2 national advisory boards focused on addressing elder issues and promoting healthy aging. Secretary Kovulich.
Thank you. Okay. Nancy, can you hear me? Okay. All right. So Harrisburg's smart. They send me not with 1, but 2 lawyers to make sure that what I say is appropriate and you know, so for those of you who don't know me, I'm Secretary of Aging Jason Kovulich, and I'm so pleased to be with you all this afternoon. I want to first take a minute to celebrate Amy and her team at the Office of Elder Justice. If everyone can please give them a hand. This is a tremendous gathering of government officials, of lawyers, of judges, of advocates, of partners, of stakeholders that are focused on elder justice. And I talk about elder justice in a whole different way than I did when I started my path in aging, because elder justice is all-encompassing. And to really tell the story of transformation that I'm here to discuss today, we really need to start at the beginning. And that was the one time I thought I was going to meet with Governor Josh Shapiro and Chief of Staff Dana Fritz, my interview. I thought this was going to be the only time I had to have that opportunity to have that one-on-one conversation with him. And what he asked me is, what do you think the Aging Network needs? And I said, we need a vision, we need a mission, we need a direction to move in. And shortly thereafter, after I became Secretary of Aging, much to my surprise, and to the surprise of many, I believe, we saw that we went to work immediately, long before Senator Collette and her colleagues confirmed me, to build Aging Our Way PA with all of you, with people in this room, with the 52 area agencies on aging. Aging Our Way PA is a multi-sector plan that's nationally recognized, and it's the model for how we're going to move forward as a system, how we're going to promote elder justice, how we're going to change the system for those that we serve for the better. In that year, we saw very quickly a plan develop with over 163 tactics, many of which are focused on elder justice issues. We also saw in Montgomery County, a year after that, the launch of our very first official plan, in which we concentrated on caregivers, which are essential in this space. If we don't have good caregivers, if we don't support good caregivers, then we see other issues arise. We see challenges from burnout. We see challenges from individuals that no longer want to serve in that guardianship type role, and we lose an alternative to guardianship. So in a very short few weeks, at the end of this month, we will be launching the Caregiver Toolkit in Pennsylvania in record time. This toolkit will be the first achievement in Aging Our Way PA that's practical, that's available, that's accessible. It will be launched in Montgomery County, where we immediately launched Aging Our Way PA. It will be available immediately in every part of Pennsylvania, in every language in Pennsylvania, and to everyone in Pennsylvania to support that work. Also in this space, we've reframed the Aging Network. We've worked with the Center for Reframing Aging on a national platform to make sure that we're reframing our work, to make sure that we are talking about older adults in language they want to hear, that we're respecting them, and that we continue to raise the message of dignity for older adults in everything that we do. We did that with our 52 area agencies on aging. We continue to do that with our stakeholders, our partners, and our colleagues to uplift the message of older adults, to change the narrative, and to make sure everyone knows aging in Pennsylvania is important, aging in Pennsylvania is good, and aging in Pennsylvania is the best place to happen, for that to happen. Also, what we've also worked on is reframing senior centers, to make sure senior centers are accessible, make sure senior centers are different, that they're not just a place for activities, that they're not just a place for meals, that they're resources for caregivers, they're resources to prevent services from being needed, there are resources to make sure that protective services interventions don't necessarily need to happen because we got out in front of a problem. The only way we're going to stop things like financial exploitation is to educate, to prevent, to make sure that older adults don't fall victim to it. Once that crime happens, it's so hard to get their resources back. So we have worked with all of you, people in this room, to reframe that network too. And as we move forward, we have made sure that we have done our due diligence, as the senator said, to reform how we monitor the work that we do. We now have a comprehensive monitoring system for the Aging Network, for the work that's done at the area agencies on aging, that's clear, transparent, publicly available, that shows the work that's being done and shows the work that we need to do and make changes to. This is about making supportive change. This is about making sure communities serve older adults the best they can. And we have achieved this under one plan, working with all of you to transform things for older adults that make their lives better, that enhance the services we provide for them. And as we move into the more formal parts of elder justice, when we talk about protective services, when we talk about the work that we've done, we've launched a new chapter, which is the guidance for our 52 area agencies on aging, with specific language about the implementation of Act 61, with directions and support, and how that will evolve in each of our 52 service areas throughout the state. We've concentrated on making sure that there's alternatives to guardianship, that guardianship is not what we reach for first, because there's 24% of the cases in guardianship in Pennsylvania fall back on an area agency on the Area Agency on Aging network. We want to make sure that every alternative is used. We want to make sure that every path is taken before we have to make that step. And we are also working to build an aging program directive to make sure that what we're doing at the department, what we're doing with the 52 area agencies on aging is conflict-free. That we do not have conflict in guardianships, that we make sure that older adults have robust representation in terms of defensive guardianship, to make sure that we have adequately made sure that we've explored all alternatives to guardianship, and that we have quality capacity evaluations before we proceed with guardianship. All of these are the things that we're working with the Office of Elder Justice in the courts, with all the judges here, with all the stakeholders here to make better for those that we serve. We've introduced evidence-based tools in Pennsylvania that are now widely available at area agencies on aging. One being the interview for decisional abilities, which those of you who are fortunate enough to be with us last year heard about. That decision-making tool, that tool that we put in the hands of protective services workers and other workers at area agencies on aging, help us to make a determination if that person has decision-making ability, or that person needs to have a capacity evaluation to formally determine their decision-making ability is compromised. All of this work, all of this change, all of this transformation happened under one plan, Aging Our Way PA, happened because we work with all of you in a very different way. We work with our partners at the Centers for Independent Living. We work with our partners from AARP. We work with our partners at Senior Law and other entities all across the Commonwealth to build a better Pennsylvania for older Pennsylvanians. So I want to thank all of you for being here with us today. I know that was a little bit long, but I want to make sure that you know the path for older Pennsylvanians is going to be a long one. And we are going to continue to work to make sure that we have the best system for older adults in Pennsylvania, that we continue to uplift their message, reframe how we look at getting older in Pennsylvania, and we keep fighting for their rights, their dignity, and their ability to choose to live as they want to, as they need to, as we move forward. Thank you.